Hey everyone, Harry here. In recent weeks, since supposedly ending their term, the Supreme Court has repeatedly made use of the so-called shadow or emergency docket to do some really important decisions or rulings, but not opinions, in cases of both legal and practical consequence. And I just thought it might be useful to go over the basics of what the hell is the shadow docket and how is it being used or abused. And it is really figuring in it is the sort of stuff of all the controversy, and there's plenty of it that the Supreme Court has done over the summer. Okay. In a funny way, as I've mentioned, all of the legal challenges to Trump moves haven't gotten to the real main event. They've all been played out at the level of, until we decide the whole thing and grant a permanent injunction or not, what do we do with this new executive order or this new effort to change the law, or this action being challenged that seems in violation of the law as it stood? And you're having many district courts on Republican, Democrat appointed, Trump appointed, recognizing and calling out the illegality of what the president is doing under a whole series of things, all this stuff with universities and law firms and efforts to influence the civil society in ways that seem to violate the First Amendment. So many things. It's really the common theme that they just ignore Congress and say, I know Congress appropriated this money or made this policy. We're just not going to do it, even though Congress does taxes and money and makes policy, and the executive is just supposed to execute. And in the immigration setting, where they seem to not give due process that the law requires. And we've had again and again and again rulings by district court judges saying, it sure looks illegal. I'm not going to find it's illegal yet, but for now, while I do decide, I'm putting this on hold. And there's a whole kind of inquiry that goes beyond just the merits for something like that. It's one thing to invalidate a presidential order when you've gone through everything, had a written opinion, briefs, etc. But this is basically, look, it looks to me that the likelihood is that I'm going to rule, say, against the administration. In the meantime, people are suffering irreparable injury. They're losing their job. They're not getting the aid that Congress had promised them, et cetera. And the balance of equities favors them. It's also in the public interest. All these are the inquiries that a district court does to say, should we freeze the linebackers while we decide? And we've had a series of decisions, sometimes in the Court of Appeals, but in this instance, really in very wide numbers of the sort we haven't seen before at the U.S. Supreme Court. And what the shadow docket means is it's sort of got 2 points to it. First, they're doing something on the basis of an emergency. They're not holding for all time, but rather saying, what the district court did to put it on hold, we don't see that. We're going to reverse that. And so for now, while this is being decided below, we're changing the status quo. And for example, the administration's policies can go into effect. That turns out to be, in many instances, the whole ball game, because we're talking, of about temporary stays that can be 2-3 years. And this is why you're supposed to look at irreparable injury. By the time everything's all said and done and courts decide, and if they go the other way, lives have been wrecked. All kinds of money has been lost. People have been dislocated. But that's what's happened. So the first thing, as I've said, is They do it on a notion of a stay. And the second, doesn't have to be this way, but it typically has become this way. No briefing, no oral argument, just a curt order that sometimes, increasingly by this Supreme Court, there's not even an explanation. We just get rid of the stay that the district court imposed. Okay, so you can see the real problems with this in effect, right? The whole soul of what the court does is based on the reasons that it provides and its responses to reasons on the other side or briefs, and you don't have that. And you're left as a society to suddenly have policies in place that are really seem to be very damaging of settled rights. And the court doesn't tell you why it's changing it, but making these supposed little temporary things are making huge changes on the ground. Okay. That has always been a possibility. When I court, a while back, and when somebody was, going to be executed, they would make a motion and the Supreme Court would decide, should we do an emergency stay? And that would just mean we'll stop the process so that there can be a more orderly consideration of the substantive claim that he should not or she should not be put to death because of it would violate the Eighth Amendment or whatever. So there's a necessity sometimes to do things according to this shadow docket. But this Supreme Court, in dealing with Trump orders has taken it to really extreme new levels. So in the 2 terms ago, 44 matters were on the emergency docket. And then last year, 113, because what's basically happening is a district court will enjoin and the administration will go screaming to first the Court of Appeals and then the Supreme Court saying, emergency, you can't keep this policy from going into effect while you decide on its legality, because that's harming us terribly. Typically, it's been, well, what's it harming exactly? And it's been kind of pretty threadbare accounts of, well, we're not able to do executive policy that the president was elected to do. That is not normally the stuff of irreparable injury. But let me just explain why this has become so prominent. 113, that should matter, but just in the last few months, Trump versus Wilcox, that involved whether a member of the National Labor Relations Board could be fired. Essentially, it deals with whether or not Congress can impose for-cause restrictions so that the president can just, as the law now is, so the president can't just fire for no reason. And the district court entered a preliminary injunction, and the court just reversed and allowed, while this is being litigated, allowed these people to be removed, even though there isn't any cause. So that's, for them, certainly, you're not going to, if you're out of your job for years, you're not going to come back to it. And then whatever it would mean that for a officer who would be more likely to follow one policy or another, they're now out being replaced by a loyal to Trump person, as is happening throughout the government, but including in instances where the argument is you don't have a right to do it because it has to be for cause. And the court, without telling us why, explaining, basically says, oh, yes, you can. You go back to doing what Trump, you go ahead and remove people, and while the case works its way, through the system. Similarly, a couple weeks later, there was a preliminary injunction that the district court entered saying DOJ can't access Social Security Administration record systems. Seems pretty important ruling. Seems like, until they decide that it's wrong, that the real equities and privacy interests and irreparable injury lies with the people whose records are being accessed. The court, by shadow docket, just stroke of the pen, the preliminary injunction is from the district court is eliminated, and the DOJ access just continues. Department of Homeland Security versus DVD. That was a district court order saying immigrants can't be deported to countries not listed on their removal orders. And they weren't given due process to challenge their deportations to these third countries. With no explanation at all, Supreme Court just lets it go forward. And even there have been some cases in which they've kind of changed the law. They've applied things when it's really clear. And, and I've just chosen a couple at random, but there's a series of cases also where Trump fires people. They sue. The district court says, yeah, it sure looks like that violated the law. You stay there, and Trump, you reinstate until we decide. And the court several times, 2 or 3 times, has just simply willy-nilly, or for reasons that kind of leave us and the community in the dark, reinstate. And they've even basically used the shadow docket to overrule cases. They've said, cases that if you took them as legal, you would have to grant a stay, and they just say no stay. So this has provoked real opposition in the court. The first case I talked about, Wilcox, Justice Kagan, and Sotomayor and Jackson say that, our emergency docket is fit for some things, but it should not be used to overrule or revise existing law, which is, basically the shadow docket ruling overruled the case that had approved of for-cause limitations. Don't need to. I mean, this is somewhat comprehensive. Don't worry about any of the specifics of these individual cases, but know a few things. One, this is happening like crazy. Case after case after case. The whole conflict is essentially being decided in the preliminary rounds by the court saying we're going to let Trump do what he wants to do provisionally, but provisionally can mean a long time. And then second, it is typically it's always a departure from the way the court's supposed to do things with full argument and briefing, etc. Sometimes that has to happen, but other times it doesn't. They can just keep the status quo, and still other times, even if they want to change it, a few paragraphs. There have been a few decisions where the court gives no reasoning, and then there's a dissent that says, what the hell, and says it properly, because it's not just the court siding with Trump, but giving really no reasons for doing it. Okay, so that's a sort of long-winded account, I know, but I wanted to bring home what it is that remains so controversial about the shadow docket and emergency docket. And it just seems that whereas typically the paradigm for deciding things in the legal system is to bring a case, work it all the way through with the district court, then proceed perhaps on appeal. Here, again and again, Trump's authoritarian, or I think at least unlawful, changing the law kind of agenda is being green-lighted in effect. Not on paper, but in effect, it's being green-lighted by a Supreme Court that is reversing district courts who have stepped forward and said, you can't do this under the current law. And the court, we are not, we are not final because we're infallible. We're infallible because we're final. Just comes in, changes things around. That's the end of the story, even though the impact is far from temporary. And it really has, in many instances, fundamentally altered, especially the relationship of power, separation and balance of power between Congress and the executive branch. So a lot of the things that are most unsettling that the courts have weighed in on in the last several months, even including after the court left for the summer, so-called, have been in just this sort of posture. And it has, as I said, hugely proliferated in the last year or two. Both the Trump administration has been very unhesitant to go forward, and the Supreme Court has indulged them quite a bit with action on the so-called emergency or shadow docket. That's going to continue, but I hope this sort of lays out both the stakes and just the way it works with the burgeoning shadow docket in the U.S. Supreme Court. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.